Freedom of Speech and the Press. Common interpretation by Geoffrey R. Stone and Eugene Warlock. Congress shall make no law abridging the freedom of speech or of the press. What does this mean today? Generally speaking, it means that the government may not jail, fine, or impose civil liability on people, organizations based on what they say or write, except in exceptional circumstances. Although the First Amendment says Congress, the Supreme Court, has held that the speakers are protected against all government agencies and officials, federal, state, and local, and legislative, executive, and judicial. The First Amendment does not protect speakers, however, against private individuals or organizations, such as private employers, private colleges, or private landowners. The First Amendment restrains only the government. The Supreme Court has interpreted speech and the press broadly as covering not only talking, writing, and printing, but also broadcasting using the internet and other forms of expression. The freedom of speech also applies to symbolic expressions such as displaying flags, burning flags, wearing armbands, burning crosses, and the like. The Supreme Court has held that restrictions on speech because of its content, that is, when the government targets the speaker's message, generally violate the First Amendment. Laws that prohibit people from criticizing a war, opposing abortion, or advocating high taxes. Example for unconstitutional content-based restrictions. Such laws are thought to be especially problematic because they distort public debate and contradict a basic principle of self-governance, that the government cannot be trusted to decide what ideas or information that people should be allowed to hear. There are generally three situations in which the government can constitutionally restrict speech under a less demanding standard. One, in some circumstances, the Supreme Court has held that the certain types of speech are of only low First Amendment value, such as a. Defamation, false statements that damage a person's reputations, can lead to a civil liability, and even to criminal punishment, especially when the speaker deliberately lied or said things they knew were likely false. New York Times versus Sullivan, 1964. B. True threats. Threats to commit a crime, for example, I'll kill you if you don't give me your money, can be punished. Watts versus United States, 1969. C. Fighting words. Face-to-face personal insults that are likely to lead to an immediate fight are punishable. Jablonski versus New Hampshire, 1942. But this does not include political statements that offend others and provoke them to violence. For example, civil rights or anti-abortion protesters cannot be silenced merely because passers-by respond violently to their speech. Cox versus Louisiana, 1965. D. Obscenity. Hardcore, highly sexual, explicit pornography is not protected by the First Amendment. Miller versus California, 1973. In practice, however, the government rarely persecutes online distributors of such materials. E. Child pornography. Photographs or video involving actual children engaging in sexual conduct are punishable because allowing such materials would create an incentive to sexually abuse children in order to produce such materials. New York versus Ferber, 1982. F. Commercial advertising, speech advertising a product or service, is constitutionally protected, but not as much as other speech. For instance, the government may ban misleading commercial advertising, but it generally cannot ban misleading political speech. Virginia Pharmacy versus Virginia Citizens Council, 1976. Outside these narrow categories for low-value speech, most other content-based restrictions on speech are presumptively unconstitutional. Even entertainment, vulgarity, hate speech, bigoted speech about particular races, religions, sexual orientations, and the like, blasphemy, speech that offends people's religious sensibilities, and violent video games are protected by the First Amendment. The Supreme Court had generally been very reluctant to expand the list of low-value categories of speech. 2. The government can restrict speech under a less demanding standard when the speaker is in a special relationship to the government. For example, the speech of government employees and for students in public schools can be restricted, even based on content, when their speech is incompatible with their standards as public officials or students. A teacher in a public school, for example, can be punished for encouraging students to experiment with illegal drugs, and a government employee who has access to classified information generally can be prohibited from disclosing that information. Pickering versus Board Education, 1968. 3. The government can also restrict speech under a less demanding standard when it does so without regard to the content or messages of speech. Content-neutral restrictions, such as restrictions on noise, blocking traffic, and large signs which can distract drivers and clutter the landscape, are generally constitutional as long as they are reasonable. Because such laws apply neutrally to all speakers without regard to their message, the less threatening to the core First Amendment concern that the government should not be permitted to favor some ideas over others. Turner Broadcasting System Incorporation versus FCC, 1994. But not all content-neutral restrictions are viewed as reasonable. For example, a law prohibiting all demonstrations in public parks or all leafleting on public streets would violate the First Amendment. Schneider versus State, 1939. Courts have not always been this protective for free expression. In the 19th century, for example, courts allowed punishment of blasphemy, and shortly after World War I, the Supreme Court held that speech tending to promote crime, such as a speech condemning the military draft or praising anarchism, could be punished. Schenck versus United States, 1919. Moreover, it was not until 1925 that the Supreme Court held that the First Amendment limited state and local governments as well as the federal government. Gillot versus New York, 1925. But starting in the 1920s, the Supreme Court began to read the First Amendment more broadly, and this trend accelerated in the 1960s. Today, the legal protection offered by the First Amendment is stronger than ever before in our history. Manders debate the first perspective, Fixing Free Speech, by Jeffrey R. Stone. 3 issues involving the freedom of speech are most pressing for the future: money, politics, and the First Amendment. The first pressing issue concerns the regulation of money in the political process. Put simply, the question is this: to what extent and in what circumstances can the government constitutionally restrict political expenditures and contributions in order to improve the democratic process. In its initial encounters with this question, the Supreme Court held that the political expenditures and contributions are speech within the meaning of the First Amendment because they are intended to facilitate political expression by political candidates and others. The court also recognized, however, that political expenditures and contributions could be regulated as consistent with the First Amendment if the government could demonstrate a sufficiently important justification. In Buckley versus Valeo, 1976, for example, the court held that the government could constitutionally limit the amount of individuals that individuals could contribute to political candidates in order to reduce the risk of undue influence. In McConnell versus Federal Election Commission, 2003, the court held that the government could constitutionally limit the amount that the corporations could spend in the political process in order to influence electoral outcomes. In more recent cases, though, in a series of 5-4 decisions, the Supreme Court has overruled McConnell and held unconstitutional most governmental efforts to regulate political expenditures and contributions. Citizens United was the Federal Election Commission, 2010. McCutcheon versus the Federal Election Commission, 2014. As a result of these more recent decisions, almost all government efforts to limit the impact of money in the political process is being held unconstitutional, with the consequence that corporations, wealthy individuals now have an enormous impact on American politics. Those who object to these decisions maintain that the regulation of political expenditures and contributions are content-neutral restrictions of speech that should be upheld as long as the government has a sufficiently important justification. They argue that they need to prevent what they see as the corruption and distortion of American politics caused by the excessive influence of a handful of wealthy individuals and corporations is a sufficiently important government interest to justify limits on the amount that those individuals and corporations should be permitted to spend in the electoral process. Because these recent cases have all been 5-4 decisions, it remains to be seen whether a differently constituted set of justices in the future will adhere to the current approach or whether they will ultimately overrule, at least narrowly construe those decisions. In many ways, this is the most fundamental First Amendment question that will confront the Supreme Court and the nation in the years to come. The meaning of low-value speech. The second pressing free speech issue concerns the scope of low-value speech. In recent years, the Supreme Court has taken a narrow view of the low-value concept, suggesting that in order for the category of speech to fall within that concept, there has to have been a long history of government regulation of the category in question. This is true, for example, for such low-value categories as defamation, obscenity, and threats. The important question for the future is whether the court would adhere to this approach. The primary justification for the court's insistence on the history of regulation is that this limits the discretion of the justices to pick and choose which categories of expression should be deemed to have only low First Amendment value. A secondary justification for the court's approach is that the history of regulation of a category of expression provides some basis in experience for evaluating the possible effects and dangers of declaring a new category of speech to have only low First Amendment value. Why does this doctrine matter? To cite one illustration under the court's current approach, so-called hate speech, speech that expressly denigrates individuals on the basis of such characteristics as race, religion, gender, national origin, and the sexual orientation does not constitute a low-value speech because it has not historically been subject to regulation. As a result, except in truly extraordinary circumstances, such expression cannot be regularly consistent with the First Amendment. Almost every other nation allows such expression to be regulated and indeed prohibited on the theory that it does not further the value of free expression and is incompatible with other fundamental values of society. Similarly, under the court's approach to low-value speech, it is unclear whether civil or criminal actions for invasion of privacy can be reconciled with the First Amendment. For example, can an individual be punished for distributing on the internet private information about other persons without their consent? Suppose, for example, an individual posts naked photos of a former lover on the internet. Is then the speech protected by the First Amendment, or can it be restricted as a form of low-value speech? This remains an unresolved question. Leaks of classified information. The Supreme Court has held that the government cannot constitutionally prohibit the publication of classified information unless it can demonstrate that the publication or distribution of that information will cause clear and present danger of grave harm to the national security. New York Times versus the United States. The Pentagon Paper case, 1971. And at the same time, though, the court has held that the government employees who gain access to such classified information can be restricted in their unauthorized disclosure of that information. Sneap versus United States, 1980. It remains an open question, however, whether a government employee who leaks information then discloses an unconstitutional, unlawful, or unwise classified program can be punished for doing so. This issue has been raised by a number of recent incidents, including the case for Edward Snowden. At some point in the future, the court will have to decide whether and to what extent the actions of government leakers like Edward Snowden are protected by the First Amendment. The next perspective. Frontiers for Free Speech by Eugene Wallach. I like Professor Stone's list of important issues. I think speech about elections, including speech that costs money, must remain protected, whether it's published by individuals, non-profit corporations, labor unions, media corporations, or non-media business corporations. Direct contribution to candidates, as opposed to independent speech about them, can be restricted, as the court has held. And I think restrictions on hate speech should remain unconstitutional, but I agree these are likely to be heavily debated issues in the coming years, and I'd like to add 3 more issues as well. Professional client speech. Many professionals serve the clients by speaking. Psychotherapists try to help the patient by talking with them. Doctors make diagnoses, offer predictions, and recommend treatments. Lawyers give legal advice, financial planners financial advice. Some of these professionals also do things such as prescribe drugs, perform surgeries, or file court documents that they have legal effect, but much of what they do is to speak. And the law heavily regulates such speakers. It bars people from giving any legal, medical, psychiatric, or similar advice unless they first get a license, which can take years, hundreds of $1,000s worth of education to get, though the government could not require a license for people to become journalists or authors. The law lets clients sue professionals for malpractice, arguing that the professionals' opinions or predictions proved to be unreasonable and harmful, though similar lawsuits against newspapers or broadcasters would be unconstitutional. And the law sometimes forbids or compels particular speech by these professionals. Some states ban psychiatrists from offering counseling, even as changing young patients' sexual orientation. Florida has restricted doctors questioning their patients about whether the patients own guns. Many states hoping to persuade women not to get abortions require doctors to say certain things or show certain things to women who are seeking abortions. The federal government tried to punish doctors who recommend that the patient use medical marijuana, which is illegal under federal law, but which can be gotten in many states with the doctor's recommendation. When are these laws constitutional? Moreover, if there is a First Amendment exception that allows such regulations of professional client speech, which professions does it cover? What about, for instance, tour guides, fortune tellers, veterinarians, or diet advisors? Courts are only beginning to confront the First Amendment implications of this source of restrictions, and the degree to which the government's interest in protecting clients and in preventing behavior that the government sees as harmful can justify restricting professional client speech. Crime facilitating speech. Some speech contains information that help people commit crimes or get away with committing crimes. Sometimes this is general information, for instance, about how bombs are made, how lock can be picked, how deadly viruses can be created, how technological protections for copyrighted works can be easily invaded, or how the contract killer can get away with his crime. Sometimes this is specific information, that is the names for crime witnesses and criminals might want to silence, the location of police officers whom criminals might want to avoid, or the names of undercover officers or CIA agents. Indeed, sometimes this can be as familiar as people flashing light to alert drivers that a police officer is watching. People are occasionally persecuted for this because they are helping others get away with the speeding. Sometimes this speech is said especially with the purpose of promoting crime, but sometimes this is said for other purposes. Consider chemistry books that talk about explosives, newspaper articles that mention people's names so that the readers don't feel anything is being concealed, or know that it accurately describe crimes as for entertainment. And sometimes it is said for political purposes, for instance, when someone describes how easy it is to invade copyright law or propose laws prohibiting 3D printing guns in trying to explain why those laws need to be rejected. Surprisingly, the Supreme Court has never explained when such a speech can be restricted. The narrow incitement exception, which deals with speech that aims to persuade people to commit immediate crimes, is not a good fit for speech that deliberately or not informs people about how to commit crimes at some point in the future. The two is a field that the Supreme Court will likely to address in coming decades. Hostile environment harassment rules. Finally, some government agencies, courts, and universities have reasoned that the government may restrict speech that is sufficiently offends employees, students, or business patrons based on race, religion, sex, sexual orientation, and the like. Here's how the theory goes. Laws ban discrimination based on such identity traits in employment, education, and public accommodations. And when speech is severe or pervasive enough to create a hostile or offensive environment based on those traits, such speech becomes a form of discrimination. Therefore, the argument goes a wide range of speech, such as display of Confederate flags, unwanted religious proselytizing, speech sharply criticizing veterans, speech suggesting that Muslims are disloyal, display of sexual materials, sexually themed humor, sex-based job titles such as foreman or draftsman, and more can lead to lawsuits. private employees are paying attention and restricting such speech by the employees. Universities are enacting speech codes restricting such speech. Even speech in restaurants and other public places, whether put up by the business owner or said by patrons, can lead to liability for the owner. And this isn't limited to offensive speech said to a particular person who does not want to hear it. Even speech posted on the wall, overheard in the lunchroom, can lead to liability and would just be suppressed by hostile